Now let's bring you updates from the Supreme Court, where the Apex Court has reserved judgment on the appeal filed by the People's Democratic Party and Labour Party challenging the judgment of the Court of Appeal, which affirmed the victory of President Bola Tinubu in the 2023 presidential election. The Allied People's Movement also withdrew its appeal against challenging the election of Mr. President before the 7-member panel led by Justice Inyang Okoro. Atiku Abubakar is seeking to bring fresh evidence to prove his disqualification appeal against President Tinubu. We have details in this report.
Security at the Supreme Court was beefed up for the hearing of the appeal filed by the PDP, Labour Party and APM. This is the first time the Apex Court will be sitting on the case after the Presidential Election Petitions Court delivered judgment on 6 September 2023. The first appeal taken was that of the PDP, where its counsel Chris Uche told the court that they have an interlocutory application. The application is seeking leave of the court to present fresh evidence. This, they say, is pursuant to Section 1371J of the Constitution. The party and its presidential candidate explained in their affidavits why the evidence was not presented at the lower court. They prayed the court to set technicalities aside and look at the substance of the case. A 7-member panel led by Justice Inyang Okoro, as well as a member of the panel, Justice Emmanuel Augim, posed a series of questions to the PDP. In his response, counsel to the PDP held that the laws in the U.S. is different from that in the Commonwealth region. Pursuant to the U.S. court order, a position was taken in which the president was represented by a counsel. He alleged that the deposition confirmed that the certificate did not emanate from the school. On his part, counsel to INEC prayed the court to dismiss the appeal. Counsel to the president told the court that a counter affidavit has been filed, urging the court to dismiss the application. He noted that the deposition of the registrar of the school is not admissible, as the deposition is dormant until the deponent comes to court to adopt it. Counsel to the APC adopted the submissions of counsel to the president. The court subsequently reserved judgment. The court also reserved judgment on the appeal filed by the Labour Party, saying a date for judgment will be communicated to parties. The court, however, dismissed the appeal filed by the Allied People's Movement for being frivolous. In a unanimous decision, the court held that it is not bound to hear every appeal, as issues raised by the appellant have been resolved by the court. The Supreme Court is not set up for academic exercise. Counsel to the APM subsequently withdrew the appeal, and it was accordingly dismissed. The Chief of Staff to the President, Femi Gbajabiamila, alongside the National Security Advisor Nuhu Rubadu, National Chairman of the APC, Abdullahi Ganduje, and the National Secretary of the APC, Ajibola Bashiru, were in court to observe the day's proceedings.
Proceedings are very, very challenging because all the contendants who wanted to claim certain issues, they did it very well. And at the same time, those who are defending did it very well. And judgment has been will be fixed later on, but I think we are the winners.
Justice Inyang Okoro noted that it is wrong to file an appeal when the appellant will not benefit from the judgment. He says the appellant ought to have gotten the hint from the judgment delivered by the Supreme Court in the case of the PDP versus the Vice President, where the court settled all issues relating to placeholder or double nomination. Celestina Iria, TVC News, Abuja.
To let us better understand what happened at the Apex Court today, I'm joined by former chairman of the NBA's PDL, that's the NBA section on Public Interest and Development Law, Monday Ubani. Thank you for joining us on the program, Mr. Ubani.
Yeah, thank you. I'm not hearing you very well. The voice is a bit low.
All right. I'll try to raise my volume from here. Hope we can kickstart the conversation. But yes, help us understand what happens when the Supreme Court reserves judgment on a case like this.
Yeah, what has happened today is that the Supreme Court took both the motion for the admissibility of fresh evidence and the opposition thereof, and then the main appeal, the substantive appeal. The councils adopted all their briefs. And so the court has reserved judgment. When you reserve a judgment, it means that you have adjourned that particular case to a later date when judgment will fully be delivered by the Supreme Court over what has brought the parties to the Supreme Court.
Is there a time frame within, a time frame by law within which the Supreme Court has to make public its judgment in this regard?
Yes, having reserved the judgment, I'm very, very sure that the Supreme Court will take into consideration the number of days that is required for them to conclude the appeal that have been filed after the decision of the lower court. The Supreme Court has 60 days within which to deliver judgment after this matter has come before it. 60 days include the time the appeal was filed. You have 60 days within which to resolve all the issues before the Supreme Court. So 60 days include the time of filing, the time of adoption, and then the time of judgment. So all must be done within the period of 60 days, which is 2 months. That is what I know that the Supreme Court will do. So they must take that into consideration. So between the time the appeal was filed and the time judgment will be delivered, all must be done within 60 days.
So it sounds like the next time we're hearing from the Supreme Court, it will be the final judgment on this matter. Is that right?
That is actually the correct position. That will bring to end the electoral process of 2023. You know that in our electoral jurisprudence, the court has the final say with the issue of validation of a candidate's fortune within the electoral system. Now we have done the voting, we have done the announcement. Some people who feel aggrieved has gone to court, from the lower court now to the Supreme Court, which is the final court to determine this issue and put paid this electoral process of 2023 to an end, so that everyone will have an rest and know that we have finally come to an end with the journey we started 2 or 3 years ago with our electoral process.
We'll talk about what you think of the time frame later on, but also joining us on the program is the former Attorney General and Commissioner for Justice in Kwara State, Salmon Jawando, Senor Advocates of Nigeria. Thank you for joining us on the program this evening. I'm sure you followed the proceedings earlier. Do you think the Apex Court was clear on its admittance or otherwise of the fresh evidence brought in by the PDP and its candidate? Mr. Jawando, can you hear me?
Yes, I'm hearing you.
Yes, I'm asking if it's clear what the Supreme Court's decision was earlier today on PDP's fresh evidence.
Oh, you see, the decision will have to be delivered along with the judgment in the substantive case. So there's no decision yet in respect of the application to adduce fresh evidence. The only thing that happened is that the Supreme Court called attention of counsel to the feasibility or possibility of doing what they are asking the court to do, having regard to the limitation of time. Because once a matter, for example, the lower court had 180 days to decide the case on the merit, and that includes the kind of evidence you want to adduce. Now that the evidence was not adduced at the lower court, the presiding Justice Okoro, was now asking, is it possible for them to now admit this evidence at this stage when the lower court is no longer in a position to admit and act on such evidence? So these are the issues, legal issues that they asked them. And I think that is a pointer to the fact that the application is dead on arrival.
So when you say dead on arrival, it was clear from the PDP counsel that the evidence they needed to tender wasn't made ready as at the time that the Court of Appeal had the presidential election petition court.
Of course. That's why they filed the application in the first instance. But incidentally, the application is brought pursuant to a provision of the rules of the court that allows the court to take, that's the appellate court, to receive fresh evidence. But this is a rule of court versus the constitutional provisions that says a case must be heard and determined within 180 days by the trial court. So, and when you have such a situation, the constitutional provision takes precedence.
Mr. Bani, do you agree with the senior advocate as to whether or not there are other conditions within which the apex court can admit new evidence, particularly when you consider the peculiarity of this case?
Well, I still maintain my position that really do appellate court admit what you call fresh evidence. It's only on exceptional ground they do that. And they do that when you can prove to them that at the time you file the case at the lower court, that piece of evidence was not available. And it's also issue of justice of the case must also be taken into consideration. Now, if that piece of evidence should have been gotten by you by sheer diligence, but you are unable to at the lower court, and you now want the court to admit it as fresh, you have to pass the hurdle of proving to them or showing to them why that piece of evidence was not able to be obtained by you before you file the case at the lower court. It's not something that is done, that can be done easily. As I say, the appellate court reviews decision of the lower court. That's what it does. It does not in any way evaluate evidence and begin to take witness evidence or oral evidence, from witnesses and begin to evaluate. That is the primary responsibility of the lower court. Theirs is to review decision that has already been taken. But the moment you are now bringing fresh evidence, then you have to comply with all the rules of fresh evidence, including cross-examination. Would that happen in this case? I don't think so. And it's something that, as I said earlier, the opposition will bring their counter, and the court now will consider it based on issue of justice and equity. We look at it and deliver decision judicially and judiciously. Judicially in accordance with the law, judiciously in accordance with equity and justice. So, and then the fairness of it all. So the court will take into consideration all that. And let's watch and see what the Supreme Court will do when they deliver their ruling and then their judgment on the substantive appeal. So we all wait. I can't make any categorical statement based on what has transpired today that the Supreme Court has made up their mind that it will not. But the point is, if they really do, and if they do, we must show them evidence of exceptional ground why they must at this point, admit fresh evidence.
How much of a precedent will this be for, our electoral litigations going forward, seeing how this has played out?
Are you asking me or my learned senior?
Oh, I'm still with you, Mr. Ubani.
Okay, it's going to be a very great jurisprudence that we are going to establish, with this particular case, especially with the admissibility of fresh evidence in electoral process. I think this is the first one I've heard where fresh evidence is being adduced in an presidential election like this. And of course, that evidence was gotten not in Nigeria, but from a foreign country. And so all the processes will be looked into. So it's going to be a great jurisprudence, if at all it will be admitted, or it will not be admitted. So either way, it establishes jurisprudence. And then even the other grounds of appeal, there are many issues that the Supreme Court have to resolve. The issue of whether when you file your case and you do not front load the evidence of a subpoenaed witness, whether that has offended the rules of the Electoral Act and then even the rules guiding the electoral process and all that. That again will be rekindled. There are so many issues. The issue of 1/3 of, is it 2/3 now of Abuja and all that will also be established. There are many jurisprudence. There are many issues that this appeal will resolve, for us as lawyers and even for judges in the country and those who handle electoral disputes. So it's going to be a great one for us as a nation. And within some days, that matter will come to an end, and all of us are looking forward to it.
Senor Advocate, a few questions were asked, posed to the Council of the PDP by the justices of the Supreme Court earlier today, one of which is asking which of the provisions of the law should guide the court, the provisions of the Electoral Act or the Constitution, and the justices even ask if they should act arbitrarily. What would think the Constitution should take precedence here? Correct me if I'm wrong, Senior Advocate.
Well, I think the Constitution will take precedence. It's even the common sense, because the Constitution is the ground norm, and where there's any conflict between the provision of the Constitution and any other law, the provision of the Constitution prevails to the extent of inconsistency. So it is the provision of the Constitution that will take precedence and will be applied. It's quite unfortunate that this is an election petition where you have time frame. It will have been more interesting if it were ordinary case, when you are talking of bringing foreign fresh evidence from foreign country. But the constitutional provision here has limited the power of the court, and the court cannot extend, it cannot elongate, neither can it expound the limit, the time limit granted by the Constitution.
So it will sound like you are saying, as it is, the court is limited here, and it cannot even probe the substance of the matter.
Of course, once the court does not have, you see, for example, now, the question you ask is that whether the trial court, that is the Court of Appeal, which serves as the Presidential Election Petition Tribunal, does it still have the jurisdiction to take the evidence as of today? If it does not have, then the appellate court, that's the Supreme Court, will not have. If it has, the Supreme Court will have. Now, 180 days are expired. So the trial court does not have that jurisdiction. So also the Supreme Court will not have. And like I said, it's quite unfortunate that this is an election petition, which it was ordinary case, ordinary civil case, where there's no time limit, but both the trial court and the appellate court.
So let's talk about the time limit, because I know that a lot of review was done to make it as short as we now experience it. But this is the 8th month after the February presidential election. What's the world best standard? Are we on time or running against time where this presidential election petition is concerned? Senor Advocate.
You see, the determination of election petition, I think before the various amendment that now culminated in 180 days for trial, 60 days for appeal, that is from the date of judgment, 180 days for trial from the date of filing of the petition. We have had so many instances of delay where you even have election petition being tried for almost 3 years. So we have come from a stage to the level we are now. Now, the next thing is that, is it possible to have a situation where petitions should be determined before the swearing? That has been the argument of people. And if I believe it is possible, the only thing we have to do is to adjust our election timetable so that election will be conducted, say, for example, a year before the swearing, so that the petitions will be disposed of before the swearing of the elected person. So it's a question of adjusting, because for now, when you have 180 days to try a petition, it is already itself killing in terms of load of work that the justices will have to do, the lawyers will have to do. So, and when you have 60 days between delivery of judgment, and that is from the date of the judgment is delivered, you have 21 days to appeal, to do record 10 days, brief 7 days for the appellant, 5 days for the respondent, another 2 days for the appellant to file reply brief. You see that this thing is choked up. The time frame is choked up so that both the lawyers involved and the justices are not, they are being worked, they are being overworked. So what we can fast, which I think should be the best now, instead of tampering with the time frame for hearing and determination of election petitions that are appeal arising therefrom, is to adjust our election timetable. Let's have our election, say, 1 year or 1 year, 6 months before the swearing, so that we will be able to conclude all the petitions before the swearing of the winner.
It's a very huge recommendation you are making. Mr. Obani, the Senor Advocate, is recommending that we have election 1 year before swearing in. But let's talk about what more can be done to fine-tune our electoral process within the framework of the Electoral Act. The senators just got back from a 2-day retreat, and they are making some huge suggestions in that regard. They are suggesting the unbundling of INEC and even electronic voting. What more do you think we can better fine-tune with our electoral law, seeing how this is playing out?
Well, I think the first thing we have to fine-tune is to fine-tune ourselves. I do not believe that. I know that there's no system that is perfect, so we don't even have a perfect system in place. But you can have a deficient system if you have perfect operation of it by those who are implementing it, the characters on the field. The thing will be perfect within the context of human being. So what we have to do first is to try as much as possible to perfect ourselves in terms of conduct, the way we conduct ourselves when it comes to the issue of elections. And it takes you to tango. If the politicians are ready to play by the rules, you already have an electoral act and the constitution that is sufficient to regulate the situation so that we can have fine and credible elections.
I hear you, Senor Advocate.
Then
let me jump in very quickly.
So we have to.
We're running out of time.
So what I'm saying is that the first part of call is ourselves, Nigerians, especially the politicians, and then the characters that are also involved in the election, the security operatives, and the supporters of the politician. It is we that we need to first of all fine-tune ourselves.
All right. Mr. Obani, let me hear your thoughts as regards what more fixing the Electoral Act needs, seeing how the proceeding is playing out after the 2023 election.
The current jurisprudence with our electoral process is that much burden is placed upon the petitioner. Now, I was a participant in the retreat of the senators at Uyo, where this issue was reviewed. And it was agreed that we may have to probably begin to look at the burden of proof. There are instances where INEC will be the one that the burden should actually shift to in order to prove that they conducted the election in accordance with the Electoral Act. There may be instances where the respondent who has been declared winner may also share in the issue of burden. And then there are instances where the petitioner will have to be the one to prove, especially where he alleges a crime and all that. So we must begin to look at that issue of jurisprudence in that regard to really lift the burden that is so much heavy on the petitioner in proving electoral cases. You know, that is one. Then secondly, we also have to look at the law. We don't have to call all the witnesses from all over, let's say a presidential election where you have how many polling units in the country. You now have to bring all the polling unit agents to come and give evidence. That is practically impossible. Section 137 of the Electoral Act that actually bring an innovation that where you have document that is satisfied by INEC, that the court should go ahead and rely on that document and not begin to ask for oral evidence because they call it, oh, you have just dumped the document on the court and all that. We must begin to look at documentary evidence and not necessarily insisting on calling witnesses to come and give evidence. That, again, will reduce the number of days we use in proving electoral cases and all that. There are so many things we need to do. Okay. And then, as he has rightly pointed out, we must ensure that we must finish our electoral process in terms of adjudication before any candidate is sworn in. The moment you swear in any person, especially the president, I tell you this, other considerations come in. Issue of money you are going to waste to ask for a new election, issue that the man is in power and has put government in place, and you now say you want to invalidate the electoral process. It's impossible. So let's try as much as possible to end all the processes, you know, before you swear in any person, any candidate, whether governor or president and all that. It's one thing we can achieve, and we can achieve it if we tinker with the law and look at our attitude also, which is also very important, and make sure that within a few months, and they reduce the burden of bringing witnesses. That is always the issue.
I'm afraid that's our time.
You have to bring.
Mr. Obani, we'll return to this conversation subsequently, but we have to go now. A big thank you to the former chairman, NBA Speaker, Monday Obani, and former Attorney General and Commissioner of Justice in Kwara State, Salmon Jawando, a senior advocate of Nigeria. Gentlemen, thank you so much for talking to us.